There's a quote that pretty much sums up a recent Supreme Court decision regarding your health insurance. Oh, what a tangled web we weave when first we practice to deceive. In the case Kennedy versus Braidwood Management, Inc., we see the tangled web the United States has woven when it practiced to deceive by claiming the power to regulate what is covered by your health insurance. So we'll look at this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation be free. I'm glad you could join me today. This is a case, I saw one thing in the titles about it, but when I got into the details, I'm like, really? Now, I'll talk more about the article I wrote and where you can find the links to all my sources, as well as some other things when we get to the end of the episode. But for now, let's just jump right into this case, Kennedy versus Braidwood Management. When asked why he wrote something a certain way, my grandfather used to say, "Where were you when the page was blank?" Now, what my grandfather used to say was both simple and enlightening. When you start from scratch, people see things different ways. My grandfather taught me to realize this and to give people some grace for starting out in a direction that was different than the one I would have chosen. However, every so often, I encounter a case where the fundamental premise is so baffling it makes me question the attorneys who brought it forward in the first place. Kennedy versus Braidwood Management is just such a case. Now, let me start with a little bit of a history. In 1984, the Department of Health and Human Services created the U.S. Preventative Service Task Force, a body that formulates evidence-based recommendations regarding preventative health care services. Now, under the Reagan administration, the Department of Health and Human Services created a task force to make recommendations for preventative health care services. No one mentioned that the power to regulate health or human services was never delegated to the United States by the Constitution. Since HHS does not execute a power vested in the government of the United States by the Constitution, Congress did not have the legal authority to pass legislation creating it. Even if Congress had given the statutory power to HHS to create such a task force, recommending preventative health care services is not a power vested in the government of the United States because, well, that would just compound the illegal activities of Congress. Not to be deterred, Congress went even further. Congress codified the task force role in 1999, establishing it as an entity, the Agency for Health Research and Quality in HHS's public health service. While Congress continued to embezzle money for this illegal task force, things got even worse after the so-called Affordable Care Act passed in 2010. Before 2010, task force recommendations were purely advisory. The Affordable Care Act of 2010 changed this by requiring most health insurers and group health plans to cover without cost sharing those preventative services that received an A or B rating from the task force. Congress compounded its error by claiming the power to force health insurers to cover services without cost to their customers simply because this task force said so. This violates the Fifth Amendment's Due Process Clause. No person shall be deprived of life, liberty, or property without due process of law. It also exceeds the powers delegated by Congress in Article 1, Section 8, to regulate commerce with foreign nations and among the several states and with the Indian tribes, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Remember, this task force was created to recommend preventative health care services. The task force currently consists of 16 volunteer members appointed by the Secretary of HHS to staggered 4-year terms. The Act also amended the governing statute to describe the task force as independent and to provide that members and their recommendations shall be independent and, to the extent practicable, not subject to political pressure. Well, this violates Article 1, Section 1 of the Constitution by giving power to the task force to write recommendations that now have the force of law. All legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Now, who in their right mind believes that any entity created by Congress could actually be independent and not subject to political pressure? After all, if Congress codified it, Congress must now pay for it. And when was the last time you saw appropriations that were not politicized? And don't forget, Congress now says that health insurance companies have to follow the task force recommendations. With that much money on the line, how can this task force not be subject to political pressure? Now, in the midst of all this deception, enters the case Kennedy versus Braidwood Management and their tangled web of logic. Plaintiffs argue that task force members are principal officers under the Appointments Clause who must be appointed by the President with the advice and consent of the Senate, not by the Secretary. That's from Article 2, Section 2, Clause 2. Okay, that seems to be a bit of a stretch. After all, Article 2, Section 2, Clause 2 of the Constitution reads, "He, being the President, shall have power, by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and councils, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments." This is where the tangled web gets worse. The district court agreed, recognizing that task force members are removable at will by the Secretary, but concluding they are principal officers because they have no superior who supervises and directs them. The Fifth Circuit affirmed the district court holding that while task force members are removable at will, they are not inferior officers because they cannot be independent and free from political pressure while simultaneously being supervised by a political appointee. The judges of both the district and circuit court seem simply to ignore the Constitution and make up rules for themselves. While the distinction between principal and inferior the judges used may make perfect sense, the Constitution doesn't vest them with the power to decide which officers not listed in the Constitution need Senate approval. But the Congress may, by law, vest the appointments of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. But this is not the basis of the court's decision. Not everyone on the court agreed with the decision. Justice Thomas dissented, joined by Justices Gorsuch and Alito. To promote democratic accountability, the Appointments Clause establishes a default rule that all executive branch officers must be appointed by the President with the Senate's approval. Article 2, Section 2, Clause 2. Congress may depart from this default by authorizing a department head to appoint inferior officers, but only if it does so expressly. It's the word expressly that entangled this court in the web of illogic. As Justice Thomas sees it, at the beginning of this suit, a subordinate official within the Department of Health and Human Services had for years appointed the task force members. Everyone now agrees that the practice was unlawful. Everyone further agrees that no one statute provides for a department head to appoint the task force members. Except not everyone agrees with your second statement, Justice Thomas. The majority of the court believes Congress has by law vested appointment authority in the Secretary of HHS through two steps. First, the 1999 statute governing the task force gives AHRQ director the authority to convene a task force to be composed of individuals with appropriate experience. Congress need not use magic words to confer appointment authority, and around the time of the founding, appoint was synonymous with allot, assign, or designate. In the absence of a statutory provision that more explicitly confers appointment authority, the AHRQ director's power to convene is naturally read to include the power to appoint. Now, is the court correct? Does the power to convene include the power to appoint? Not according to the Merriam-Webster Dictionary Online, which defines convene as to come together in a body. Now, it seems that Thomas has a point, and the power to convene doesn't appear to include the power to appoint. For example, under Article 5, Congress is required to call a convention for proposing amendments. That does not include the power to appoint the delegates. The lack of a statutory provision to confer appointments does not confer that power. The fact that Congress screwed up doesn't mean the courts can read into their laws. But what about their second step? Second, Reorganization Plan Number 3 of 1966, ratified by Congress in 1984, transfers to the Secretary all functions of the public health services and its officers, employees, and agencies. This explains Justice Thomas's statement that at the beginning of the suit, a subordinate officer within the Department of Health and Human Services had for years appointed the task force members. If the power of the AHRQ director were transferred to the Secretary, that would seem to fix the legal problem. Well, maybe. Because as Justice Thomas points out, In ruling otherwise, the court treats the default rule as an inconvenient obstacle to be overcome, not a constitutional principle to be honored. And it distorts Congress's design for the task force, changing it from an independent body that reports directly to the president to one subject to the control of the Secretary of HHS. It seems the more I look at this case, the more tangled the web gets. Let's see if we can untangle this mess just a little bit. Let's start with what the court majority found. Held. Task force members are inferior officers whose appointments by the Secretary of HHS is consistent with the Appointments Clause. Interestingly, SCOTUS did not find that the task force appointments were constitutional because Congress vested the Secretary of HHS with that power, but because they redefined inferior in a way that allowed it. Task force members are inferior officers because their work is directed and supervised by the Secretary of HHS, a principal officer through two main sources of authority. The Secretary's authority to remove task force members at will provides a powerful tool for control. Beyond at will removal, the Secretary has statutory authority to directly review and block task force recommendations before they take effect. Not a very solid footing, since it appears Congress did not explicitly vest the power of appointing task force members to the Secretary of HHS. However, this argument does seem to dismantle Justice Thomas's assertion that the task force reports directly to the President. Next, what about the legal authority of this task force? As Justice Thomas noted in his dissent, the case concerns the U.S. Preventative Service Task Force, a body that issues legally binding recommendations regarding preventative healthcare treatments. If the recommendations are legally binding, then they're no longer recommendations. Furthermore, for them to be legally binding, they are effectively making law, which is a power reserved to Congress, not the executive departments. The court has frowned on the idea of Congress being able to delegate their power to another branch in its non-delegation doctrine. The non-delegation doctrine is the principle that Congress cannot delegate its legislative powers or lawmaking ability to other entities. And lastly, remember that Congress, and only Congress, has the power to regulate interstate commerce, but that does not include the power to force health insurance companies to pay for services neither them nor their customers requested. This is what happens when we, the people, allow our elected representatives to ignore their oath to support the Constitution, even if it's for what they think is a good reason. Not just creating the task force, but in their failure to impeach federal judges for their bad behavior. Going back to my grandfather's quote, "Where were you when the page was blank?" The problem here is that the page wasn't blank. There is ample documentation that the recommendations of the task force are not law and can have no legal force whatsoever. The task force was created by an unconstitutional act and delegated powers not vested to the government of the United States. As the Supreme Court stated in the case Ex parte Siebold, an unconstitutional law is void and it has no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment. So why did the attorneys for Braidwood Management take such an odd and twisted approach to the illegal actions of the task force? Probably because the courts have so twisted and ignored the Constitution, they simply make up new rules as they need them. And this was the best approach they thought they had. To me, that's a truly bad state of affairs. My head still hurts a bit from trying to wrap it around this twisted set of logic. Rather than pointing out that the task force is unconstitutional, the law that created the task force is unconstitutional, giving them the power to make effective law is unconstitutional, they went for how the people are appointed, in a really questionable argument. The whole thing is a mess. The whole thing is a disaster. Yet it's still being used today to impact you. You see, you're paying for health insurance that are covering things that the task force says should be covered. Not what you want covered, not what your insurance company wants covered, but a group of 16 unelected bureaucrats, what they think should be covered. That's a pretty bad setup for me. It's one of the reasons why I keep saying you, just like John Jay said, every member of the state ought diligently to read and study the Constitution of his country, teach the rising generation to be free. By knowing our rights, we'll sooner know when they're violated, be the better prepared to defend and assert them. That comes from reading and studying, which is why I keep pointing you back to my book, The Constitution Study. This is my study, clause by clause, through the Declaration of Independence and the Constitution. And it's written in plain conversational English so that everybody can understand it. So individually or in small groups, you can read and study and understand not just the Constitution, but how to defend and assert your rights. You can find out more at the website constitutionstudy.com/shop and pick up a copy. And if you like, I'd even sign it. You can also help by supporting some of our affiliates, like the course I found called The Miracle of America. It really looks at our history from the Pilgrims to the Founding Fathers. It helps explain why the Declaration of Independence is written the way it is, why the Constitution was written the way it was, and why our federal government is formed the way it is. Now, I liked it so much, I made a deal. If you go to constitutionstudy.com/1776 study guide, you'll be taken to a custom landing page just for my listeners where you can not only research the product, research the course and instructor, but enroll for a lesson on God's natural law absolutely free. And I don't know about you, I think free is good. Again, constitutionstudy.com/1776 study guide takes you to the custom landing page. Do your own research, check it out, but be sure to enroll for your free lesson on God's natural law, the foundation of our unalienable rights. And if you like that, well, you can sign up for the whole course for just $17.76. Also, try using your cell phone. Patriot Mobile is America's only Christian conservative wireless provider, and they support the same things we do. They want to protect our rights, our right to life, liberty, and the pursuit of happiness. They take a portion of every dollar they earn and they use it to support organizations that are defending your rights, including the Constitution Study. Just go to patriotmobile.com/constitution and find a plan that works for you. See if you're eligible for a discount. If you decide to sign up, use the code Constitution at checkout to get free activation. So protect your rights and the rights of your family with your cell phone by going to patriotmobile.com/constitution, signing up today, and don't forget to use that code Constitution at checkout to get free activation. I also hope you just share the content we create here at the Constitution Study, and hey, maybe bring a friend next time we get together for the Constitution Study.
Love your neighbors and have a few good friends.